Jim, the shadow docket, as Will and I have used the term, is actually meant to cover everything that the Supreme Court does, away from the high-profile, 60 or 70-page opinions that we get in the cases that are argued. So if we think of the 60 or so some odd rulings that the Supreme Court hands down every spring with lengthy decisions after multiple rounds of briefing and argument, we think of that as the merits docket. The shadow docket is basically everything else. And emergency applications, these requests from parties to adjust the status quo while cases are working their way to the merits docket, are just one part of the shadow docket, Jim. I mean, another big part is the way that parties even ask the Supreme Court to take up appeals in the first place. What are called petitions for writs of certiorari, or cert petitions. But the emergency docket, as some folks call it, has become a real flashpoint over the last 7 or 8 years, because more than ever before, we're seeing efforts by governors, by presidents, by private actors to get the Supreme Court to weigh in long before the case has worked its way all the way through the courts.